Arthur Vance did not look like a man who could crash a regional banking empire. At 64, he wore flannel shirts that had lost their color 3 presidents ago, drove an old pickup with a rusting tailgate, and possessed the quiet, slow-moving patience of a retired surveyor. When he walked into the gleaming, marble-tiled branch of Apex Mutual Bank in downtown Portland, he was holding a crumpled slip of paper and a single crisp $12 money order. He had spent 40 minutes finding a parking space, all to pay a recurring, monthly administrative fee on a dormant access easement. The teller, a young man whose name tag read Bradley, didn't look up from his monitor for the first 30 seconds. When he finally did, his eyes swept over Arthur's worn work boots and the faded document in his hand with immediate, practiced dismissal. Arthur explained the situation calmly. He needed to make the $12 payment to ensure his small parcel of land remained officially connected to the county utility grid, a bizarre clause buried in a property deed from the early 70s. Bradley let out a short, nasal laugh. He didn't try to hide it. He informed Arthur that Apex Mutual had updated their digital processing systems 3 weeks prior. The bank no longer accepted manual ledger overrides for accounts carrying less than a $50 balance, nor did they process physical money orders for legacy easements without a $50 manual handling tariff. In short, Bradley told him, the bank system wouldn't even let him punch in a $12 credit. It was a waste of the bank's time, and frankly, a waste of Arthur's too. Bradley advised him to let the easement lapse, mockingly adding that $12 wouldn't even buy a decent lunch downtown anymore, let alone protect a strip of dirt. Arthur didn't raise his voice. He didn't demand to see a manager. He simply asked Bradley to stamp the back of his money order as refused by institution. So he had proof he attempted to pay. Bradley, eager to clear his queue, slapped the red ink stamp onto the paper, signed his initials, and slid it back across the counter with a smirk. That smirk was the exact moment Apex Mutual signed its own death warrant. Arthur walked out into the rain, got into his truck, and dialed a number he hadn't called in 15 years. The man Arthur called was Marcus Thorne, a senior forensic auditor who spent his days unearthing buried liabilities for corporate acquisitions. Marcus wasn't a flashy lawyer, he was a mathematical bloodhound. When Arthur showed him the stamped, refused money order that evening, Marcus didn't laugh. He grew incredibly quiet. They actually stamped it, Marcus whispered, tracing the red ink. Arthur, do you realize what Apex Mutual just did? They didn't just refuse $12. Legally speaking, they defaulted on a restrictive covenant tied to a public utility corridor. To understand why a $12 fee mattered, Marcus had to explain the concept of prior continuous use. In the financial world, megabanks like Apex Mutual grow by absorbing smaller, local banks. Over 40 years, Apex had swallowed up dozens of community lenders, including the old First Forestry Bank of Oregon. When these mergers happen, the megabank inherits thousands of ancient, overlooked contracts. Most are standard mortgages, but some are strange, historical anomalies. Arthur's father had been a timber cruiser in the 1970s. In 1973, he had sold a massive tract of land to First Forestry Bank for a commercial development project, but he kept one tiny, strategic acre right in the center for his family's cabin. To guarantee that the family would always have access to water, electricity, and the main road, the 1973 contract stipulated that the bank must maintain the surrounding infrastructure. In return, the Vance family would pay a symbolic $12 fee every single month to keep the ledger active. If the bank ever failed to accept that payment, or failed to maintain the ledger, the contract stated the entire master deed would revert to its original 1973 boundaries for legal review. For decades, the bank's older clerks had just pocketed the $12 and clicked a button. But Apex Mutual's new, high-tech, automated software didn't understand history. It only understood profit margins. By refusing the $12 because it was too small to process, the bank had technically breached a foundational property agreement that governed the very land their massive, multi-million-dollar regional headquarters was built upon. Marcus knew they needed undeniable proof before the bank's legal team could cover their tracks. The digital county records only went back to 1985, everything before that was digitized via low-resolution scans that often omitted handwritten surveyor notes. They needed the original, physical truth. The next morning, Marcus and Arthur drove out to the state archives, a sterile, climate-controlled warehouse filled with long rows of gray metal shelves. They weren't looking for a digital file. They were looking for the physical 1973 land map, drawn by hand with India ink on heavy vellum paper. They spent hours pulling heavy, dust-covered leather binders. The archival staff was unhelpful, complaining about the lack of digital index numbers for records that old. But Marcus knew exactly what code to look for based on the First Forestry Bank's original charter. As the clock ticked past 3 p.m., Arthur's fingers brushed against a thick, faded canvas folder tucked away in the bottom of a forgotten crate. When they untied the frayed string and unrolled the map across the grand viewing table, the room seemed to go cold. It was the complete, unedited 1973 regional master grid. There, drawn in meticulous detail by a master surveyor, was Arthur's tiny 1-acre plot. But it wasn't just a plot. The map featured a thick, hatched red line slicing directly through the center of what was now Apex Mutual's corporate campus, parking structures, and main vault. Marcus pulled out a magnifying glass, focusing on the handwritten legal descriptions in the margins. His eyes widened. The $12 payment wasn't just for an easement. According to the original 1973 map notes, Arthur's family didn't just have a right to use the land, the bank's current modern buildings were legally sitting on an uncleared, conditional title. Because the bank had mocked and refused the $12 fee, the condition was broken. The entire multi-million-dollar corporate campus was suddenly sitting on land they no longer legally owned clear title to. Marcus Thorne spent the next 48 hours isolated in his office, surrounded by high-resolution scans of the 1973 vellum map and a stack of Oregon property statutes. To the untrained eye, a mapping error from 50 years ago was just a historical curiosity. To a forensic auditor, it was a structural fracture in a multi-billion-dollar corporation's balance sheet. Marcus knew exactly how Apex Mutual operated. They were currently in the final stages of a highly publicized, $400 million acquisition by a national banking conglomerate. For an acquisition of that scale to close, Apex Mutual had to guarantee that all its physical assets carried clean, unencumbered titles. A title is the legal backbone of real estate. When a bank builds a 6-story corporate headquarters, investors assume the land beneath it is securely owned. However, the 1973 map revealed a devastating legal reality known as a reversionary interest with a condition subsequent. When Arthur's father signed the contract with First Forestry Bank, he didn't just sell the land outright. He sold it under the strict condition that the utility corridor and access rights remained permanently active, tied to that symbolic $12 monthly processing fee. By stamping that money order, refused by institution, the teller hadn't just been rude, he had legally documented the bank's non-compliance with the core condition of their own land title. In property law, when a condition subsequent is broken, the original owner or their heir gains the immediate right of re-entry. Arthur didn't just own a random acre next door anymore. He now possessed the legal leverage to challenge the ownership of the ground beneath the bank's feet. Marcus drafted a formal notice of title defect and noncompliance. He didn't send it to the branch manager or a generic customer service email. He sent it via certified courier directly to the office of the General Counsel at Apex Mutual's corporate headquarters. Accompanied by a certified copy of the 1973 map and the stamped money order. At 9 a.m. on Thursday, the head of Apex Mutual's legal department, a veteran corporate attorney named Cynthia Vance Noel, no relation to Arthur, opened the courier package. Her initial reaction was amusement. Megabanks receive hundreds of frivolous threats from sovereign citizens and disgruntled borrowers every week. But as she flipped past Marcus's cover letter and looked at the high-resolution copy of the 1973 vellum map, the color left her face. Cynthia was an expert in commercial real estate acquisitions. She immediately recognized the signature on the bottom of the 1973 map. It belonged to Chief Surveyor Thomas Vance, Arthur's father, who had been the county's leading land authority for 3 decades. His work was legally flawless. She pulled up the bank's internal digital title portfolio for the corporate campus. The digital file showed a clean title, but when she tracked the historical chain of custody, she realized the automated system had flagged a minor legacy exception code during the 2012 software migration. The system had simply ignored it to keep the database clean. The minor exception was the $12 ledger requirement. By automating their branches and cutting legacy staff, the The bank had systematically eliminated the only human beings who knew how to process the old manual accounts. Cynthia immediately called an emergency meeting with the executive board. "We have a catastrophic title defect," she announced without preamble as the executives took their seats in the glass-walled boardroom. "The land beneath this building, including our primary secure data vault, is subject to an active reversionary claim. The heir of the original grantor attempted to cure the monthly easement fee, and our branch staff rejected the payment and stamped it as refused." The chief executive officer, a sharp-tongued man named Richard Sterling, stared at her in disbelief. "Are you telling me a $12 checking account error jeopardizes a $400 million merger?" "It's not an account error, Richard," Cynthia replied coldly. "It's a land covenant breach. If this heir files a formal quiet title action in state court before our merger closes next month, the title insurance company will pull their coverage instantly. Without title insurance, the acquisition fails, our stock value collapses, and the federal regulators will halt our expansion." Sterling leaned back, his mind racing. "So we buy him out. Offer him $10,000 to sign a quitclaim deed. If he's a 64-year-old living in a flannel shirt, $10,000 will seem like a fortune." What Sterling didn't understand was that Arthur Vance wasn't looking for a quick payout. He had watched his father spend his final years fighting against the slow creep of corporate development that swallowed up local family farms and small businesses. Arthur had kept paying that $12 a month not out of habit, but out of respect for his father's foresight. That afternoon, a junior associate from Apex Mutual's legal team arrived at Arthur's modest home. He didn't bring a lawsuit, he brought a polite smile, a sleek leather briefcase, and a pre-drafted settlement offering $15,000 in exchange for Arthur's signature on a release waiver. Arthur sat on his front porch, looking at the young lawyer. Marcus Thorne sat right beside him, a notebook open on his lap. "We appreciate the offer," Marcus said smoothly before Arthur could even speak. "But we've already performed a preliminary valuation of the encumbered parcel. Based on the 1973 map boundaries, your corporate vault, your underground fiber optic trunk line, and 60% of your executive parking lot sit directly on Arthur's family land. The current market valuation of that specific footprint, adjusted for the commercial revenue generated by that branch, puts the liability closer to $7 million. The young lawyer laughed nervously. $7 million. That's absurd. This is a technical mapping oversight from the 70s. No judge in the state is going to evict a regional bank over a $12 money order. We aren't asking the judge to evict you, Marcus replied, leaning forward with a calm, terrifying confidence. We are filing an injunction to freeze all construction and property transfers involving the parcel, pending a full forensic survey. And we are filing it tomorrow morning at 9. The local press is already very interested in how an automated banking algorithm accidentally forfeited its own corporate headquarters." The young lawyer's smile vanished. He realized, with a sinking feeling in his chest, that this wasn't a negotiation. It was a hostage situation, and the bank had supplied the rope. By 8:45 a.m. the following morning, the marble corridors of the Multnomah County Courthouse were bustling, but the real storm was brewing inside courtroom 412. Marcus Thorne and Arthur Vance sat quietly at the plaintiff's table, looking entirely outclassed by the small army of corporate defense attorneys occupying the opposite side of the aisle. Cynthia Vance Noel sat at the center of the defense table, surrounded by 3 junior associates and 2 senior litigation partners. Apex Mutual had flown in from Seattle. The presiding judge, Honorable Evelyn Vance, again, no relation, just a common regional pioneer surname, adjusted her glasses as she reviewed the emergency motion for a preliminary injunction filed by Marcus. A preliminary injunction is an extraordinary legal remedy. It effectively freezes the status quo, halting any business activity, sale, or modification of a property until a full trial can determine the rightful owner. For a bank in the middle of a multi-million-dollar merger, an injunction was the equivalent of an induced coma. Apex Mutual's lead litigator, a man named Henderson who spoke with a booming, theatrical baritone, took the podium first. He didn't waste time attacking the map, instead, he attacked the scope of equity. Your Honor, Henderson argued, gesturing aggressively toward Arthur. The plaintiff is attempting to weaponize a minor, ancient administrative clerical oversight to hold a vital civic institution hostage. A $12 fee. The bank automated its intake systems, a standard, modern business practice. A computer program threw a minor processing exception, and now Mr. Vance wants to halt a corporate acquisition that employs over 800 people in this state. The doctrine of laches and the principle of substantial compliance dictate that a court of equity cannot grant such an absurdly disproportionate remedy. Henderson was relying on a standard corporate defense, arguing that the economic harm to the giant corporation vastly outweighed the minor grievance of the individual. He painting Arthur as a greedy opportunist trying to cash in on a computer glitch. When it was Marcus's turn to speak, he didn't match Henderson's theatrical volume. He walked calmly to the podium, carrying nothing but a leather-bound folder containing a certified copy of the 1973 land map and the stamped, refused money order. "Your Honor," Marcus began, his voice steady and clinical. "The defense wishes to frame this as a digital glitch. But a computer program does not possess legal agency. A corporation is bound by the contracts it inherits. When Apex Mutual acquired First Forestry Bank, it legally assumed all covenants running with the land. This wasn't a passive oversight. Mr. Vance physically went to the branch. He presented the exact contractually mandated fee. The bank's authorized agent didn't just experience a system error, he actively mocked the plaintiff, refused the legal tender, and physically stamped the document as refused by institution. Marcus opened the folder and placed the high-resolution photograph of the red stamp on the digital projector, illuminating the courtroom screens. In property law, Marcus continued, a condition subsequent is absolute. The moment the bank refused the payment, the covenant was broken. The 1973 map explicitly states that upon breach of this specific condition, the title reverts. This isn't a question of equity or balance of hardships. This is a question of pure title integrity. If Apex Mutual does not own a clean title to the land beneath their vault, they cannot legally sell it to their acquisition partner next month. An injunction is not only appropriate, it is required to protect the integrity of the county's land registry. Judge Evelyn Vance leaned forward, looking intently at the 1973 map projected on the screen. She focused on the handwritten surveyor notes from Arthur's father. "Mr. Henderson," the judge said, turning her sharp gaze to the bank's legal team. "Did your client check the historical physical deeds before implementing this automated system?" Henderson shifted his weight, clearing his throat. "Your Honor, the bank utilized a certified title data migration service which scanned all records back to 1985. "So you didn't look at the physical vellum," the judge interrupted. "You relied on an algorithm to sweep away 50-year-old property rights because it was more cost-effective than hiring human archivists. And then your branch staff actively refused the plaintiff's attempts to maintain his lawful easement." Cynthia Vance Noel closed her eyes. She knew right then that the judge was going to rule against them. The bank's arrogance had created a perfect legal trap. Judge Vance tapped her gavel once. "The court finds that the plaintiff has demonstrated a substantial likelihood of success on the merits regarding the title defect. Furthermore, allowing the upcoming corporate merger to proceed while the underlying land title is under an active cloud would cause irreparable harm to the public trust and the county land system. I am granting the preliminary injunction. All asset transfers, structural modifications, and merger proceedings regarding the corporate campus lot are frozen pending a full evidentiary survey." The courtroom erupted into a flurry of hushed whispers. Henderson looked as if he had been slapped, while his junior associates frantically began typing on their laptops to alert the executive board. As they walked out of the courtroom, Cynthia intercepted Marcus and Arthur near the elevators. Her professional composure was entirely restored, but her eyes were deadly serious. "Mr. Thorne, Mr. Vance," she said, her voice quiet so the passing reporters wouldn't hear. "You won the opening skirmish. But you need to understand something. Apex Mutual has a war chest of $40 million set aside purely for protracted litigation. We can file appeals, venue changes, and procedural challenges that will drag this case out for the next 7 years. Arthur is 64. Do you really want to spend the rest of your retirement sitting in depositions while our lawyers drain your savings?" Arthur looked at the high-powered corporate attorney, then down at his own weathered hands. He smiled softly. "My father spent 30 years drawing lines in the dirt, Ms. Vance Noel. He taught me how to stand exactly where a line is drawn. I've got nothing but time. But Marcus knew the bank wouldn't just sit back and wait for an appeal. They were desperate. And when a multi-billion-dollar bank gets desperate, they stop playing by the rules of the courtroom. Richard Sterling did not become the CEO of Apex Mutual by conceding ground. The moment the preliminary injunction hit his desk, he bypassed the legal department entirely and brought in Vanguard Strategy Group, a high-priced crisis management and public relations firm known for neutralizing corporate threats. If Arthur Vance couldn't be bought, and if the courtroom was going to enforce the letters of old laws, then Sterling would change the battlefield entirely. He would make Arthur's life so miserable, and his public reputation so toxic, that the retired surveyor would beg to sign the quitclaim deed just to escape the pressure. Within 48 hours, the narrative in the local business press shifted dramatically. Front-page headlines in the regional papers began framing the courthouse victory not as a triumph of individual property rights, but as a direct assault on the community's economic stability. Paid editorials labeled Arthur a land-speculating extortionist and a frivolous litigator, who was deliberately sabotaging a $400 million merger out of spite. The articles falsely implied that if the merger collapsed, Apex Mutual would be forced to close local rural branches, potentially causing dozens of everyday citizens to lose their jobs and their access to small business loans. Arthur's phone began ringing at all hours of the night. Heavy breathing, hang-ups, and anonymous callers labeling him a parasitic old man ruining the town's economy. Even his local grocery store became hostile. The owner, a man whose commercial line of credit was held by Apex Mutual, suddenly found himself unable to look Arthur in the eye when ringing up his groceries. The psychological warfare was calculated, precise, and completely legal. But Vanguard Strategy Group didn't stop at media manipulation. They sent a private investigative team out to Arthur's modest property to dig up any leverage they could find. They reviewed his tax records, his old utility bills, and his father's estate filings. And on Tuesday afternoon, they found exactly what they were looking for. A representative from the county building inspection office, accompanied by 2 private security guards hired by the bank, showed up at Arthur's property with a formal order of non-compliance. The bank's investigators had discovered that a small equipment shed Arthur's father had built in 1978 sat exactly 6 inches over the western boundary line of the family's retained acre. Because the bank technically owned that western adjacent parcel, they claimed Arthur was actively trespassing and operating an illegal, unpermitted structure on corporate property. The notice gave Arthur 72 hours to completely demolish the historic shed, or face an immediate retaliatory lawsuit for civil trespass and a daily $5,000 fine. To make matters worse, the bank's legal team simultaneously filed an emergency motion to disqualify Marcus Thorne as Arthur's representative. Claiming Marcus had a structural conflict of interest because he had once performed a routine asset valuation for an insurance company that subleased a single office space from an Apex Mutual subsidiary 5 years prior. It was a frivolous, hyper-technical legal stretch, but its purpose wasn't to succeed. Its purpose was to tie Marcus up in procedural red tape and separate Arthur from his advisor. Marcus met Arthur at his cabin that evening. The pressure was visibly wearing on the older man. Arthur sat at his kitchen table, staring at the county code violation notice. "Maybe we should just let it go, Marcus," Arthur said quietly, looking out the window at the old wooden shed his father had built with his own hands. "They're turning the whole town against me. People I've known for 20 years won't look at me at the post office. And now they want to tear down Dad's shed. It's just a strip of dirt." Marcus placed his hands on the table, leaning in. "Arthur, look at what they're doing. If they actually had a strong legal case to overturn the injunction, they'd be in the Court of Appeals right now. They aren't. They're playing dirty because they are terrified. They know that 90-day merger clock is ticking down. If that clock runs out, their buyers walk away, and Richard Sterling gets fired by the board of directors. The shed, the PR campaign, the conflict of interest motion, it's all smoke and mirrors to make you blink before they have to show their cards in the final forensic audit." Marcus knew they couldn't just play defense anymore. They needed an equalizer, and they needed it before the 72-hour demolition deadline expired. Marcus realized that if the bank was going to use county inspectors and municipal records as weapons, he needed to dig deeper into the state archives than the bank's digital scanners had ever gone. He spent the entire night back in the climate-controlled archive room, bypassing the 1973 map and focusing instead on the original corporate charter of First Forestry Bank, the entity Apex Mutual had absorbed. He discovered that when First Forestry Bank bought the surrounding land from Arthur's father, they hadn't just signed a property deed, they had entered into a joint public-private infrastructure partnership with the State Maritime and Transport Authority to secure tax-exempt bonds for the construction of the utility corridor. Marcus discovered a hidden clause buried in the 1973 state transportation filings. Because public bonds were used to finance the infrastructure around Arthur's acre, the $12 monthly fee wasn't just a private transaction between Arthur and the bank. The bank was legally acting as a trustee for a designated public utility corridor. By refusing Arthur's payment and attempting to terminate the easement, Apex Mutual hadn't just violated a private contract, they had committed an unauthorized, illegal modification of a state-sanctioned public infrastructure corridor without the approval of the State Utilities Commission. This meant the bank's automated system update hadn't just triggered a private land dispute, it had technically placed Apex Mutual in direct violation of state administrative utility laws, a regulatory offense that carried automatic, mandatory federal disclosure requirements. Marcus smiled as the sun began to rise through the archive windows. The bank thought they were playing a local game of property intimidation. They didn't realize they had just triggered a regulatory tripwire that would alert the federal regulators overseeing their entire $400 million acquisition. Marcus Thorne didn't waste time filing a countersuit in local court. He knew that playing on Apex Mutual's home turf would only invite more delays, appeals, and public relations mudslinging. Instead, at 8 a.m. on Thursday morning, Marcus bypassed the state judiciary entirely. He drafted a formal, comprehensive regulatory non-compliance report and submitted it directly to two entities, the Federal Deposit Insurance Corporation, FDIC, and the State Public Utilities Commission. Under the Bank Merger Act, any insured depository institution undergoing a multi-million-dollar acquisition must maintain an unblemished record of regulatory compliance throughout the entire vetting period. More importantly, federal law dictates that if a merging bank becomes involved in an active, unresolved regulatory dispute involving state-sanctioned public infrastructure or utility corridors, the acquisition approval process must be frozen automatically until a full federal compliance audit is completed. By failing to process Arthur's $12 fee and attempting to unilaterally terminate a state-tied utility corridor, Apex Mutual had committed a major compliance infraction. Marcus attached the certified 1973 vellum land map, the stamped, refused by institution, money order, and the original 1973 public bond filings he had unearthed from the state archives. He hit send, copying Apex Mutual's general counsel, Cynthia Vance Noel, on the transmission. The reaction inside Apex Mutual's executive suite was instantaneous panic. At 10:15 a.m., Richard Sterling was in the middle of a conference call with Wall Street analysts, reassuring them that the merger was on track despite a minor, frivolous local property dispute. Suddenly, his assistant slammed a printed document onto his desk. It was an urgent administrative stay issued by the Federal Oversight Board, notifying Apex Mutual that the $400 million acquisition was being officially suspended for a mandatory 90-day regulatory review period. Sterling's face turned an ashen white. He abruptly ended the conference call, threw his phone onto the desk, and screamed for Cynthia to get into his office. When Cynthia walked in, she didn't look panicked, she looked utterly exhausted. "I told you, Richard," she said, shutting the door behind her. "I told you this wasn't a standard property dispute. Arthur Vance didn't back down because he has the truth on his side, and Marcus Thorne just figured out that our automated system broke state utility laws. Fix it." Sterling shouted, his veins bulging against his collar. "Call the governor, call our lobbyists, file an emergency appeal. We cannot let this merger freeze for 90 days. If the market sees a federal suspension, our stock will plummet 20% by the closing bell, and the buyers will invoke the material adverse change clause to walk away completely. There is no appeal for an administrative review suspension, Richard," Cynthia said quietly, sitting down across from him. "The federal board doesn't care about our lobbyists. They care about title integrity and public utility corridors. If we fight this in a federal regulatory arena, they will audit our entire legacy database. Do you know what they'll find? They'll find thousands of other old, manual contracts that our automated system has been quietly ignoring or deleting for the last 10 years to cut costs. If that happens, we don't just lose the merger, we lose our banking license. Sterling stared at her, the reality finally sinking in. The absolute arrogance of his corporate machine had blinded them to the foundation they were built upon. A $12 payment, handled by a dismissive teller who wanted to clear his queue, had brought a financial empire to its knees. What do they want? Sterling asked, his voice suddenly hollow and deflated. They don't want your money, Richard, Cynthia sighed. But you're going to have to pay them exactly what they're asking for to save this bank. At 2 p.m. that afternoon, a sleek black town car pulled up to Arthur Vance's modest home. Cynthia Vance Noel stepped out, carrying a single manila folder. She didn't bring an army of junior associates, and she didn't bring a private security escort. She walked up the wooden steps of the front porch, where Arthur and Marcus were waiting for her, drinking coffee out of faded ceramic mugs. Cynthia sat down on an old wicker chair opposite Arthur. She placed the folder on the table between them. Mr. Vance, she said, her voice completely devoid of corporate posture. I am here on behalf of the board of directors of Apex Mutual Bank. We are prepared to offer you a full, legally binding settlement to resolve this matter permanently. The bank will immediately withdraw the county code violation against your family's shed. We will issue a public apology in the regional newspapers retracting all previous statements regarding your character, and we will establish a permanent, irrevocable endowment in your father's name at the State Historical and Surveying Society. Arthur took a slow sip of his coffee, looking at her over the rim of his mug. And what about the $12 fee, Ms. Vance Noel? Cynthia opened the folder, revealing a newly drafted, legally binding master property deed. The bank has modified its regional processing software. We have created a permanent, manual ledger override specifically for your account. Your family's $12 monthly payment will be accepted in perpetuity, processed by a human clerk at our main branch. The 1973 land map will be officially recognized as the definitive, unchallenged boundary line for our corporate campus footprint. What do they want? Sterling asked, his voice suddenly hollow and deflated. They don't want your money, Richard, Cynthia sighed. But you're going to have to pay them exactly what they're asking for to save this bank. At 2 p.m. that afternoon, a sleek black town car pulled up to Arthur Vance's modest home. Cynthia Vance Noel stepped out, carrying a single manila folder. She didn't bring an army of junior associates, and she didn't bring a private security escort. She walked up the wooden steps of the front porch, where Arthur and Marcus were waiting for her, drinking coffee out of faded ceramic mugs. Cynthia sat down on an old wicker chair opposite Arthur. She placed the folder on the table between them. Mr. Vance, she said, her voice completely devoid of corporate posture. I am here on behalf of the board of directors of Apex Mutual Bank. We are prepared to offer you a full, legally binding settlement to resolve this matter permanently. The bank will immediately withdraw the county code violation against your family's shed. We will issue a public apology in the regional newspapers retracting all previous statements regarding your character, and we will establish a permanent, irrevocable endowment in your father's name at the State Historical and Surveying Society. Arthur took a slow sip of his coffee, looking at her over the rim of his mug. And what about the $12 fee, Ms. Vance Noel? Cynthia opened the folder, revealing a newly drafted, legally binding master property deed. The bank has modified its regional processing software. We have created a permanent, manual ledger override specifically for your account. Your family's $12 monthly payment will be accepted in perpetuity, processed by a human clerk at our main branch. The 1973 land map will be officially recognized as the definitive, unchallenged boundary line for our corporate campus footprint.